Concord versus Amanda Mount. Amanda Mount versus Concord, 2501975. Mr. Gallup.
Good morning, Your Honor. Creighton Gallup, P63002 on behalf of Concord Cooperative.
Ms. Mount?
Amanda Mount.
I'm at a loss as to what is going on here. I thought the case was settled. And I'm getting motion after motion after motion. And when people are done filing motions, they're filing more motions. I mean, everything from certifying a class to now motion for protective orders, sanctions for abuse of process. I mean, I don't know what to say anymore. Are you guys settling this or not settling this?
Your Honor, if I could interject here, we have mediated on at least 2 occasions with Judge Hessen, and I'd like to say on a personal note, I appreciate her efforts to try and get this thing resolved. I have submitted to Ms. Mount, this is on a second occasion, a revised agreement that I believe encapsulated the final terms that we had worked out with Judge Hessen after doing a walkthrough of her unit. First one I was denied access, but Judge Hessen facilitated a second inspection. We went in there, and we believe we'd worked out a deal. I have provided that to Court Administrator Jen on Friday and a copy to Ms. Mount. I have not heard back from Ms. Mount as to whether those terms are acceptable or not. So the ball is in her court. The only motion that we have filed is after the 14th motion was filed by Ms. Mount last week. We just had to put an end to this. We just can't keep up with these motions. A lot of these are evidentiary in nature, and they're not relevant.
These kinds of things. You can raise this at the time of the hearing. Motion to strike police report and certain board member statements as inadmissible, misleading, and tainted by conflict of interest. Motion to preserve rights, objections, and defenses. I mean, I don't want to be rude. It seems like you're enjoying playing lawyer here, and that's okay. But at some point, I'd understood the case was settled. That's what I'd understood. Now I have seemingly I got stacks of stuff here. And I don't know what's happened. Can you just tell me what the basic tenet of the conditional dismissal terms were, Mr. Gallup?
If the court's comfortable with that, because I do know that she had filed a request for a waiver of the jury trial, and I don't want to cause any problems with you if you're going to be the jurist on this one, Your Honor. I can tell you it was a conditional dismissal in general that had arranged for some terms that she would be able to stay so long as the general rules had been followed. I don't want to get into all the specific details, but Judge Hessen worked very hard with both parties to get some middle ground here. I thought this was resolved. I've just not heard back from Ms. Mount from the proposal that was sent to her last week, which is the second draft, which incorporated newer terms for her protection after the inspection that we'd done with Judge Hessen.
Well, do I dare ask what the new terms were?
No, it specified certain items that we were going to repair in her unit that were basis of her counter complaint, things that she'd said that had been lingering that had gone unaddressed. It was all going to be taken care of here within the next 30 days.
I don't know what to say. I don't know what to say. I thought it was settled. Did they change something?
No, the habitability was settled, but not the misconduct.
Remind me, what specific misconduct?
Withholding my work order, filing a police report when I wasn't even there.
So,
And it all started after I started enforcing my shareholder rights for withholding a work order.
can you elaborate on that, Mr. Gallup?
Yeah, she keeps referencing these police reports that are not a part of the court record right now, and that's one basis of one of her motions. I really don't know how to respond to it. It's not a part of the court record yet. She's insistent on having a police report.
File police reports.
I had to do it. There was at least one or two police reports, one of which when the police were contacted after there'd been a threat made about the site manager, she threatened that she was going to beat her up. And I believe there was at least one other police report sometime where she believes there's conflicting statements from maintenance guys that she wants to call as witnesses. I don't think there's any probative value here, that nothing's been submitted to the court as a part of this. And if this is something that would need to be excluded or included as a part of an exhibit at trial, there are limiting motions and processes that would be handled for something like that. It's very preliminary that she would raise this issue right now. I don't think it's relevant. Regarding the unit itself, she's made claims that her work repairs went unanswered. I think the court knows this. This has been part of the record. There were some delays due to COVID.
Yeah, you know, but that's not right either.
And that's why, and Your Honor, and we have worked diligently with the defendant, and we have worked with.
Do you have time limits in there and the conditional dismissal as to when all these repairs are going to take place?
Yeah, they were already supposed to have taken place last month, but she wouldn't let us into the unit. She changed that. Now it's scheduled, judges, but we'd rescheduled it pursuant to new agreement to the end of September, because it's going to require her and her family.
Slow down. I can't hear. I can't pick up two of you at the same time. You think I can hear you both and comprehend you both? Was a date set for them to come in?
Yes.
Did you let them in?
The first time, no.
Why?
Because I would prefer an extra set of eyes, because.
Did you tell Judge Hessen you weren't gonna let them in the first time without her being there?
No, but
Why did you not let them in then?
Well, because there's bigger issues.
So they're seeking to have you removed. And it sounds to me like you're winning. That's what's befuddling. Hang on. It sounds to me like you're winning. If there's a conditional dismissal, Leonard, they have obligations, you have obligations, but as far as I can tell, you've won.
I understand that, Your Honor, but a conditional dismissal, I've done nothing to deserve a conditional dismissal. I did what I'm allowed to do.
Well, doesn't the conditional dismissal set forth that they're going to undertake all this work? And that there's to be no further violations by you, and as long as there aren't, that will be, the case will remain dismissed? Look, if you guys don't want to settle it, I have no issue with that.
Yeah.
All I know is I thought it was settled. And it seems like every single or every other third day it just seems like I get motion after motion. I come back from a conference, I got motions after motions here. And I'm thinking, what is going on? I thought we were waiting for a conditional dismissal. Did you graduate from college?
Almost.
Maybe you should go to college and go to law school.
It's not my intention. I have stage fright. Like, this is not what I want to do, but I do know my rights, and I know I didn't do anything wrong. And.
All right. I understood it was settled. Is there anything else I can do to try to resolve this? You're right. If it's not a jury trial, I'm going to listen to the facts and I'm going to make a determination as to what the facts are and apply the law.
Your Honor, as far as I'm concerned, the ball is in her court. We provided a proposed agreement, a revised agreement. This is at least the second draft that we've given her last week, and I've not heard from her. So if she's telling the court and me today that she's not interested, we got to put this on the litigation track. I'd rather resolve it if we can. My clients come a very long way from where they were at, and it's just very frustrating that all this treasure's been spilt on this. These costs are getting assessed back against the members themselves. This is expensive stuff, so we just need a fish or cut bait. I'd rather resolve it, but we have to go to trial. So be it.
I don't even know where to start.
Well, I can't hear very well, Your Honor. Did Ms. Mount, is she definitively saying she is rejecting what was provided to her last
The
week?
way it sounds to me.
Okay.
I can tell you you're in the wrong court if you're talking about certifying this as a class action. Then I have other issues that I need to address, like, well, how long are you going to be gone on vacation?
I'll be back the 17th, Judge. We do have a preliminary date for the motion that we'd filed, the motion for the protective order. The court had given us October 6th. I know the court doesn't want to put this out further than necessary. I've not received a response to her motion. We just filed it last week. So obviously she would have a little bit of time to respond.
We don't need to decide anymore. There's so many here.
You've only
I've got packet after packet after packet.
You've made decision on one general motion, which was her motion to transfer,
Right.
And we submitted an order.
Motion for reconsideration. I got emergency motion for protective order. I've got motion to preserve rights, objections, and defenses. Notice of waiver of jury demand. Police report is inadmissible upon hearsay. Motion to certify and transfer to circuit court. Motion for class certification. I think there's a couple more in here.
There were still 5 or 6 preceding from the first batch that she'd filed that the court has not had an opportunity to rule upon.
I know.
Yeah.
I don't even know. All right. Okay. Okay. Well, if you guys don't want to settle, you don't want to settle. I guess we'll just go forward. I will schedule Jennifer.
Yes, Judge.
A notice going out on all these motions. We're going to set them for October. Was it the 6th that we already set the one with Mr. Gallup?
We gave them the 6th as a tentative date, yes.
Okay. So if, okay, let me see here. All right. So I want you to set forth all motions that are going to be heard on that. I want it, I don't even know. So all motions, you're going to separately list each one.
And Judge, for quick reference, if you look at our motion for the protective order, I believe we listed them all for your convenience. I think we listed them. There's 1 through 14. That should help the court.
There's 14 of them?
I believe it was close to 14 that she filed. We've only filed 1 motion.
I thought there was more. I must be getting bad at counting. Motion for reconsideration will be the first one on the list. Set them all for October 16th. Any responses are due by
October 6th.
Register, if you would, by September the 29th. Can you do that, Mr. Gallup?
I believe we've responded to all of those, including the 2 recent ones she filed last week. I think
Match them all up and give them to me, Jennifer. If there's
Yep.
any other ones, you have to respond by September 29th. You likewise have until September 29th, ma'am, to file any responses, okay?
The only other thing I'd ask the court, Your Honor, we've already relied on what we thought was an agreement to get these contractors out there. This is our duty anyway to make repairs. We're going to ask that the court order her to cooperate with any type of necessary inspections in the interim. There are a couple things that need to be done. One is the flooring. The second requires a contractor to come out there and displace them. We'd already made a hotel reservation to put them out. This could.
Hotel reservation? Who out?
Because they're going to be renovating the bathroom upstairs. HUD requires them to relocate. We've already made arrangements when we're talking with Judge Hessen to get her and her family accommodations if they choose to use them, because they're going to have to rip out the bathtub and replace the flooring upstairs. These are the repairs that were scheduled for August that we rescheduled for at the end of September. If we reschedule it again, this may not happen until October, November, and that'll just.
So wait a minute, when are you scheduled to do the work?
29th, September 29th.
Okay, and you paid for a room for Ms. Mount and her family?
They've already made one arrangement. They're making a second one. They're not out of money until she doesn't show up. We can still cancel. My understanding is we're making another reservation for her for a period of a week. It's possibly a week it's going to take to do the upstairs.
What do you want me to order? Tell me what you want me to order.
That she will cooperate with the necessary repairs as proposed in the.
If you're going to complain about them not doing repairs, hang on.
Okay.
If you're going to complain about them not doing repairs, you need to let them in to do repairs,
I
right?
understand that, but my children's stuff has been stolen from the last time, so I appreciate it. If I could get them out of the house and do it without them worrying, because they're traumatized from the last time.
From what last
From
time?
our stuff being stolen from
When?
the contractors.
When?
When we were out last time in the hotel for 3 months.
Judge, I don't know what she's talking about. We have never had any reports.
What do you want to, I'm not following you. Do you want them in to do the repairs?
Yes, I did. I just, my kids.
Well, I understand, but do you want to take them to the hotel?
I mean, yeah, I don't have a problem. I just, everybody's showing up at the door. I would prefer just to keep them out of it as much as possible.
Well, tell
Because
them,
they're
wait a
afraid to
minute,
leave.
wait a minute, wait a minute. I'm trying to help you here. If you want the repairs done, they have to gain access to the property.
Yes.
So do we have a date for them to come in and effectuate the repairs? He says September 29th.
September 29th.
And she would leave on the night before because we'll be there in the morning. We make the arrangements for the whole week for her to be staying at the hotel. We'd even change the location to make it more convenient and a newer.
Is that okay?
Yeah.
So you're agreeing to leave on the 28th of September and remain in a hotel until what, about the 5th of October?
Give or take, yes, Judge. That was their projection. And there's one additional.
Wait a minute, wait, slow down. I don't want to hear give or take. I'm not writing give or take in an order. Tell me how long it's going to take, and then she can agree to leave during those days, and you guys can have access to the property.
The contractor assured us it would be done by that Saturday, which was October 4th here. Let me look here.
So you're going to put them up in a hotel until the 5th?
Yes, absolutely. She will not be out 1 cent from that. We will make the arrangements for her. We're required by HUD to provide that to her.
Okay, so I want to make sure this is okay with you. September 28th, the night of you vacate,
Okay.
right?
Yeah.
You come back on the 5th.
Okay.
In what hotel? I want this all in an order.
It's in the proposed consent agreement. It is located off of North Line. It's the new Detroit Townhouses, I believe is the name of it. We've given her the information before. It was Judge Hessen's suggestion. It was a newer location.
Well,
Do you know where? Do you know where?
Well, there was like 2, and last I knew there was 2 different ones.
I just want to know, do you know which 2 they're talking about?
No, North Line, Detroit. I thought it was on Eureka.
It may be Eureka by 75. It's right there off 75. It's a new place. I believe it's a Marriott. Just it's on the south side of the road. We'll send her an email, Judge, Your Honor, and if we get done before, we'll be happy to let her know.
Can I put this in an order right now, and then I don't have to worry about this? This is so incredibly petty with so many things going on here. I want the hotel listed. I want the order saying she's going to leave the property to allow the plaintiff to effectuate repairs, which consist of A, B, C, D, E, and F, or whatever they are. And then that she's going to, the plaintiff is going to pay for and relocate her and her family to the hotel at the Marriott or whatever it is on whatever street in whatever city in whatever state.
We can do that. It's already in the order. All I got to do is cut and paste, and I get it to you this morning.
Pull out your order. I have a feeling nothing's going to go right on this case. If Judge Hessen, if you guys were not allowed access to effectuate repairs, I mean, look, I'm not going to babysit here. I'm telling you right now, I am not about to babysit. That's ridiculous. She wants repairs. She won't let you in. You guys go in. Douse down being told people are stealing things. I'm telling you, I am not going to babysit. So put it right in your order. Pull out the conditional dismissal and tell me what we're adding in that order. And then I'm going to order it, and then there's not going to be any problems. And if somebody doesn't let somebody in or somebody doesn't show up with the contractor, there's going to be a serious penalty.
Yeah. So there are three portions of the repairs. The first one requires a contractor and her removal from the property or family. That's the one we're talking about starting September 29th. There's also a flooring issue in the kitchen where the tiles are starting to pop up. That is something that would be done internally. They do not have to be displaced for that. That can be done anytime from now until the 29th. All we would need is her cooperation. If we
All right, then you're going to put it in there. The flooring will be repaired on or before September 29th. Defendant / counter plaintiff shall provide contractors hired by plaintiff to gain access for the purpose of repairing the kitchen floor. What else?
The other will happen after, when they'll do painting and they'll do the what they call it, finishing work after the contractor.
When's that going to take place by?
That'll be right after the work that's done.
Let's say by November 1st,
Sure.
Plaintiff shall paint the residence wherever it is, whatever walls, whatever portion of whatever wall, maybe the 13 inches and 1 foot on the east wall, the north corner, but then don't paint anything else. You put this all specifically in an order, and I want it on here right now, please. I'm not going to go through this. This is nonsensical garbage as far as I'm concerned.
I agree.
I mean, you guys, I thought had an agreement, and I'm getting motion after motion, and I'm not gonna babysit. They don't pay me enough to babysit.
I agree.
So let's get the order. Let's put all the language in here, because I have a feeling when you submit the order, there's going to be an objection, and I'm going to have a hearing, and you're going to be in Italy, and then we're going to delay this, and I'm not delaying it. We're moving forth on this. So tell me. In fact, I want you to draft the proposed order now.
I'm working on it, Judge.
And I want it, Ms. Mount's not leaving until she looks at it and she approves it, and I'll sign it. You're going to send it to Jen. Jen, tell him where to send it.
Mr. Gallup, you can email me that at jen@33court.com.
Okay, Your Honor, I'll have it to you within the hour, probably within the next 20 minutes, actually.
Thank you very much. And then Ms. Mount, we're going to print out the copy of the order.
Good.
I want to see it too, Jen. So when you give her a copy, I want to see a
Yes,
copy.
I'll print a couple copies and bring them down as soon as I get
Thank
it.
you very much. Thank you.
Judge, if I may, before though, they go, what time on the 6th for these motions? Do we want to do the afternoon or late morning?
What day of the week is that?
It's a Monday.
Well, I probably have sobriety for it, right? Don't I? Let me think. 25th, 8th, 22nd, the 6th is a Monday. Why don't you set them at 1:30 on Monday, the 6th?
Okay.
Okay?
Thank you.
Thanks.
Okay, Judge, let me get working on the order. Do you want me to pop back into the Zoom after we've sent it to you, Your Honor?
I do. I want you to send it to Jen, and then you can wait 10 or 15 minutes. She can look at it. I'll look at it. And if there's corrections to be made, we'll make them, okay?
It's only going to be about the repairs, and she's going to cover just the one portion, so we'll get it to you here. in
Just
20
be
minutes.
specific. I want to know where she's staying. Everything.
Understood.
Okay?
Thank you.
Thank you.
See you.
Concord versus Amanda Mount, 2501975 LT.
Good morning, again, Your Honor. Creighton Gallup, P63002 on behalf of the plaintiff.
Your name, ma'am?
Amanda Mount?
All right. Did you look at the order?
Yes, I did. Under page 2E, it just has the wrong address.
Oh,
Yeah.
replace the molding in the dining room at the floor underneath the dining room window on a wall that borders 22872. Where do you live?
70.
Oh, just a clerical error, just a clerical note, Judge.
Yeah, so you're going to change that.
Other than that, all is well.
Judge, do you want to make a circle on the two? I can send it to you if you just want to.
No, you know what? I just want you to, I'm going to change that.
I can send to the change, Judge. You can take my initials. It's just a Scrivener's error.
Ms. Mount, you agree to all these
Yes,
terms?
yeah.
You do?
Yes.
You do, right, counsel?
Yes, Judge.
And I'm just gonna make a note, parties agree to order as presented. I did change that, okay?
Great. Thank you, Judge.
I haven't read through this, so I'm trusting that you looked at it real well and you know everything, right? This is all good with you?
Yes.
Good enough. Go down the hall, we'll give you a copy, we'll send it over. I'd encourage you two to keep talking if you can, okay?
Go to,
All the way down.
All the way down to the civil department.
okay, thank you.
All right. Do you have Garrett?
Thanks, Judge.
Thank you. I'm gonna need you to call in Emily. Kylie Magyar, 25M117655. Is Kylie Magyar here?
Yes,
On
Your Honor.
Zoom, Judge.
Oh, I know what this one is. Okay. Ms. Magyar, your name?
Kylie Magyar.
Hey, counsel, your appearance?
Morning, Your Honor. Robert Hayes, Assistant Attorney General here for the people, P69006.
Mr. Berry? Mr. Berry? Okay, your appearance?
Good morning, Your Honor. Brian Berry appearing on behalf of Kylie Magyar.
I wasn't trying to make this more difficult, but you guys agreed to take this under section 771.1. All you did was stipulate, you're just discharging her from probation supervision. I need a motion. I need an order, a stipulation from you, Mr. Hayes, if you're satisfied that you could send over right now, moving to dismiss. I mean, that's
We
your,
did that, Judge.
I don't see it.
Mr. Hayes's office sent over,
A step for early discharge. He doesn't have a
Well-
motion to dismiss.
no, we did that first, and then they sent over, Nolly Pros.
Okay, well, I never saw the Nolly press.
Let me see if I can find it and forward it to the court.
I don't believe I have what I like on a 771 case is for you to simply move to dismiss. Terms have been complied with. That's a little different than granting an early discharge from probation. Everybody's entitled to early discharge from probation if there's no violations within the preceding 90 days. So is there a problem with you just sending one over, Mr. Hayes? Like a stipulated, just like you wrote on the stipulation here, only people move to dismiss, defendant compliant, we're done. You can send it over right now. I don't care if you handwrite it.
Your Honor, we sent one. I can send it again. Where would you like me to send it?
Lisa, what's your email?
Lisa@33court.com.
Please do that. I do not see where you sent one. I'm not trying to make this bigger than it is.
No worries, Your Honor. We're taking care of it right now.
But I figured,
Judge-
yeah,
I do have one in my email, but it's from March. Oh, that might be the original plea.
that's the stipulated plea.
Yeah,
We
that's the only
received-
thing I have.
We never received the Nolly Pross on this. We received the
I
stipulated.
just forwarded it again.
Perfect. Lisa, would you bring that down here and I'll take care of this right now? I
Yep.
sure didn't mean to make this bigger than it is, but I wanted to make sure that all the Ts were crossed and the Is dotted, so she's dismissed as of today rather than just discharged. Some prosecutors in the past, I'm not saying very often, have taken the position that, well, we agreed on 6 months, or we agreed on 12 months, or we agreed on 9 months, and that's what she has to do to fulfill the terms and conditions of the 771 status or 769 status. I haven't had it happen in a while, but do we have that then, Lisa?
Yep, I'm on my way down.
Perfect. Okay. Ms. Magyar, I'm going to just ask you to raise your right hand, please. You solemnly swear or affirm under penalties of perjury the testimony you'll give in these proceedings will be the whole truth, so help you God?
Yes.
Since you were in court on April 1 of 25, when I sentenced you, have you been arrested?
No.
You have any other charges pending?
No, sir.
Any contact with the police?
No, sir.
All right, just give me 1 second. Again, guys, I'm sorry that we had to, I just didn't feel comfortable just signing that without a dismissal. So I'm not trying to cause you guys any additional work or anything. Let me just make sure everything's in order. It sounds like it is, and I'll go ahead and dismiss the case.
Thank you, Your Honor.
Oh, perfect. Yeah, see, I never got this before. I'm going to go ahead and take it. Yeah, you moved to dismiss, case dismissed. It also, what's today, the 26th? 7th. It also calls for destroying the arrest. What was this plea to again?
Disorderly, Your Honor.
Now, I don't think I can sign this, gentleman, with number 7 on there. You're entitled to have this removed from lien if it's nollie-prossed. You're moving to dismiss because the terms are compliant. On a 771 case, the conviction is there. It doesn't come off. It's a non-public record that still reflects the conviction. So I don't believe I can sign this with number 7. If you disagree with me, Mr. Berry, you can tell me, but I don't believe I'm able to sign that.
Judge, under the statute, under 28.243, I think it is, and the statute numbers are down at the bottom, but I think it's the 28.243. As long as there has been a dismissal prior to trial, the court can grant it, is my understanding.
Hang on. Nothing's easy anymore. I don't have this. Okay, hang on 1 second. Cite me this is a lengthy statute. Cite me that. Cite me the provision.
Oh, it's been a while since I read it. Give me a second. It would be section 8, Judge.
I don't think that's correct. If they agreed to nollie-pross this case without a plea, otherwise I've got to read it where every one of these have to be taken off. They're entitled to a return of the prints and photographs.
Judge, it doesn't, the statute itself does not specify that there cannot be a plea in the matter. It just said that.
Yeah, but wait a minute. You're telling me that all these like 7411, 769, 4A, HIDA, all those, they're entitled to return of the photographs and prints? That's not correct.
769 or 4A and all of those are a little bit different. Those are delayed.
Those are even better. There was never a conviction entered on those.
That is correct.
There's never a conviction entered on a 7411, 769, 4A or HIDA unless and until there's a violation and the court accepts the plea. Look, I'm very confident I'm right. And I got people here. I've got a lot going this morning. I'm not signing this with number 7. If you want to send me a little memo and send it a copy to Mr. Hayes, I'll be glad to look at that. But I'm not always right when I think I'm right, but overwhelmingly. So I don't think you're entitled to a return of that. I mean, I see criminal histories every day, and otherwise, those would be even better. 769 would never be on there. None of those. They'll show dismissed. It will show disposition is dismissed, but now where it comes off the lien. So I'm taking that off. I'm signing the order. I'm dismissing the case. Again, if you think that's wrong, I invite you to file a little motion. It doesn't have to be lengthy, and I'll be happy to set it for hearing. But I'm very certain that I'm right. Again, I'll never say 100% about anything, but I'm sure I'm right. Okay, thank you both. Have a good day. Good luck to you, ma'am. Case dismissed. You're all set. Do I have somebody here? DeCale Quatez Dumps. 25B706301. Who's his lawyer? Mr. Demps, your name?
Yeah, DK Debs.
Who's your lawyer?
Your Honor, it's Derwood Haynes.
Mr. Haynes? I thought it was you, but you were sitting back there quietly, probably studying. How you doing?
Studying the law. Good, Judge. How are you?
Good. Your appearance?
Derwood Haynes says the Brownstown matter.
Yes.
On behalf of Mr. Debs.
All right. Detective, your name?
Good morning, Your Honor. Crystal Tulod's Detective, Brownstown Police Department.
All right, so I did the signing on record on this, I believe, yesterday, and defendant is charged with assault and intent to do great bodily harm less than murder or by strangulation and domestic violence. How is he going to proceed here?
He's standing here.
Sir, I'm going to advise you of your rights. You have the right to remain silent. You do not have to say anything. If you say something in or out of court, whether orally or in writing, it can be used against you. You have the right to be represented by a lawyer, not only today, but at all subsequent court proceedings. If you cannot afford one, you can apply for one at public expense. Also, if you choose to submit the question with law enforcement officials, you do have the right to be represented by a lawyer at that questioning. Do you understand that?
Yes.
You have the right to a probable cause conference within 14 days. You have the right to a preliminary exam within 7 days thereafter. Probable cause conference will be September 9th at 8:15. September 16th at 10:30 will be your preliminary exam. That will be in front of me, okay? So I'm going to listen to anything that's said regarding bond, and we will go from there. So he's going to fill out a petition for court appointed. Go ahead, counsel.
Thank you, Judge. Regarding bond, Mr. Debs is 27 years old. I looked through the file. I didn't see any criminal history. I asked him about that. He indicates that is true. Is that consistent with the court's information?
It is.
And we checked.
At least his criminal history. He had, let me just double check one thing. No, that's it. He has no criminal history.
And we verified the address that's in the file. Your Honor, provided additional information. I think that email and phone number for him. He is employed. He's been driving trucks for 6 years. I'm not sure whether he's going to qualify. I think he's filling out the request for court appointed attorney. He doesn't have a lot of debt. He also makes pretty decent money. But we do want to ensure that he has an attorney one way or the other when he comes back.
He drives out of state.
What's that?
He drives out of state?
I believe so.
Is that true? Sir, talk to me. Is that true?
No, I drive local.
I didn't hear you. You drive what?
Drive locally. I'm home every.
Okay, so you don't leave the state. Good enough. Go ahead.
So, Your Honor, based on that, we would ask for a personal or low-end bond because this is steady employment, his contact with the community, is not correct.
Remind me, Detective, these two are not going out anymore? They had a former dating relationship, or no, they went out on date night, right?
Yeah, they were together for 3 years, according to the victim, Your Honor. With respect to bond, although I won't speak to an amount, in terms of conditions, as you recall from yesterday, the allegations in this case are fairly severe. He smashed the victim's head off a metal trash can, resulting in a bruise as big as a baseball to her forehead and her hairline. He also choked her with both hands and put her in a chokehold, which resulted in redness, marks, and bruising and scrapes to her neck. Given the nature of the allegations and what occurred, we would ask for a couple conditions. We would ask for a GPS tether. We would ask that he have no contact with Kira Jones. We would ask that he be required to surrender any firearms for safekeeping to the police department while this matter is pending.
And remind me, she lives on this Kings Point Boulevard address?
No, Your Honor, she's living in Southfield.
He lives at Kings Point Boulevard, right?
Yes, Your Honor.
How much money does he make?
That makes about $120,000.
I'm gonna. Yeah, if I send him downtown to get a GPS tether, he's gonna be stuck there for 5 days. That isn't fair. I mean, these are allegations. Does he have the money to go get his own? You have the money to go pay for a GPS tether? I can't quote you how much they are, sir. If I order you not to be released until fitted with a tether, you might be sitting in there until today. You might be sitting in there until Tuesday.
I can go get a tether. I'm not sure of the process of that. I'm not sure of the process. You just have to let me know the process.
Call in Beth. Give me a second, okay?
Okay.
I'm telling you, I want you to stay away from the victim.
Yes, I understand.
I hope you do, because if I find out you had any contact with her, we're going to have a big problem and you're going to be sitting in jail for a long time. So I'm going to tell you your bond conditions to begin with. You cannot leave the state without the consent of the court. You cannot violate any law or ordinance. You must appear in court as directed. No contact at all with Kiera Jones. I hope I'm pronouncing that correctly. Kearia, Kiera Jones. You cannot write, phone, see, text, email, or communicate with her, or have anybody else do any of those things for you or on your behalf. You're not to have any contact with prosecution witnesses. You're not to be within 2 miles of the victim, her residence, or her place of employment. You're not to go near there. So no contact with her, no contact with prosecution witnesses. You cannot possess firearms or dangerous weapons. You're not to be within 2 miles of the victim, her residence, or her place of employment. Do you understand that?
Yes.
He's been printed and photographed, correct?
Yes, Your Honor.
I'm going to set a 5,000, 10% bond. You're going to have to post $500 to secure your release. I'm going to check with Ms. Wiles here. Ms. Wiles, your name?
Elizabeth Qualification, Your Honor.
Look, this gentleman has the money to pay for his own GPS tether. If I send him downtown, he's going to be sitting there for Lord knows how long. What is the best way can you communicate with Brownstown or get on Zoom with them and tell them how to go about it? I'm ordering 5,000, 10%. I'm assuming you can post that, sir, correct?
Yes.
So then you have to get a tether by the end of the day. Is he still going out to house arrest?
Yes, GPS tether, just a regular, not a steel cuff, is $100 enrollment
Right.
and $10 a day to have. So financially, what it will be. And yes, I can jump back in my office, jump on Zoom with Brownstown, and actually fax that referral over to Brownstown to provide to him after I instruct him.
You have to be on that GPS tether by the end of the day. You have to be on that GPS tether by the end of the day. Do you understand me?
Yes.
You're going to post your 500. You're going out to house arrest in Livonia. Warren, I'm sorry. You're getting fitted with the GPS tether, and then you'll be all set. But you have to, and you can't be within 2 miles of the victim or residence or place of employment. Do you understand that?
Yes, I have one question though. Like I drive locally, so if I'm at work, that doesn't count, right? If I'm driving past 8 miles.
You just tell them, I don't know where she lives exactly. You tell them if they're going to be able to track you, and they're going to be able to tell her if you're within 2 miles. But if you notify them of that yes, you drive on I-75, which might be within 2 miles of her residence or place of employment, you're not going to end up getting a violation.
Okay.
As long as you stick with that routine. Do you understand me? They're going to be able to tell where you're going at all times. So they'll know if you're going toward a residence or place of employment, and they're going to know the other too, whether or not you're just going somewhere else in our incidentally or coincidentally, I should say, in the realm of the 2 miles while driving in the course of the employment, okay?
Okay.
All right, I wish you well. Any other questions?
No.
Detective, anything else?
No, Your Honor, thank you.
Thank you very much. All right,
Thank you.
thanks. So you'll get on with them. Thank you.
Yes, I will.
Paul Joshua Tyson, 250-720-272. Okay, your name again?
Detective Lieutenant Steve Mercury, Rockwood Police.
Raise your right hand. You solemnly swear or affirm under penalties of perjury that the testimony you will give in these proceedings will be the whole truth, so help you God.
I do, Your Honor.
Okay, go ahead.
Your Honor, 8/25 of 25 at approximately 10:30 in the evening, officers Frierson and Harshbarger with the Rockwood Police Department was dispatched to the Rebel Gas Station, 22855 Hanover Drive in the city of Rockwood in reference to a VIN verification. Upon the officers' arrival, they spoke with Todd Taylor. Taylor stated he spoke with a subject by the name of Timothy on Facebook Marketplace, who was currently selling a white 2009 GMC 350 heavy-duty pickup truck with a VIN number of 1 G George, T Tom, J John, K King, 83699 F Frank 136375. Mr. Taylor stated that he was purchasing the vehicle for $9,500. However, when he looked on Kelly Blue Book, the value of the pickup truck was over $19,000. He thought it was suspicious in nature and requested that the officers do a VIN verification due to the suspicious nature and the sale price of the vehicle. The officers ran the VIN through Lean SOS, and the vehicle currently came back as a stolen vehicle out of Old Bridge Township, New Jersey. Shortly thereafter, the vehicle pulled into the parking lot of the Rebel gas station, and the driver was identified as Paul Tyson. Officers confirmed the VIN number that was attached to the vehicle, as well as Mr. Tyson had the title to the vehicle as well. When Mr. Tyson stated that he was selling the vehicle for a family member, when officers asked what was the family member's name, he refused to answer at that point and requested an attorney. A lien check confirmed that the vehicle was stolen out of Old Bridge Township, New Jersey. And when I spoke with the detective in Old Bridge, she stated it was a sale went bad there where it was used a fraudulent check to purchase the vehicle. That's why it was reported stolen. I also did a value of the vehicle check through Kelly Blue Book myself for the value of the truck by VIN number, and it showed that the value of a private sale is $19,855. I submitted a warrant to the Wayne County Prosecutor's Office, and you have a charging document in front of you.
You have these prior convictions here, February 8 of 11 for robbery armed and felony firearm, and also September 22 of 22, retail fraud first.
Yes, Your Honor.
Based on your sworn testimony, I find the crime of receiving and concealing motor vehicle was committed. There's probable cause to believe the crime was committed by the defendant, and that the defendant has the prior convictions giving rise to the habitual fourth offense notice. So I'm authorizing, I'll note you signed, I'm signing and dating the complaint and the warrant for the arrest of the defendant. All right, so Mr. Tyson, your name, sir?
Paul Tyson.
Okay.
Bureau Detective Paul Tyson, Leadway, former reading skill.
Sir, I'm going to advise you of your rights. You have the right to remain silent. You don't have to say anything. If you choose to say something in or out of court, whether orally or in writing, it can be used against you. You have the right to be represented by a lawyer not only today, but at all subsequent court proceedings. Again, if you cannot afford one, I will appoint you one at public expense. Also, if you choose to submit to questioning with law enforcement officials, you do have the right to be represented by a lawyer at that questioning. Do you understand that?
Yes, sir.
You have the right to a probable cause conference within 14 days. You have the right to a preliminary examination within 7 days thereafter. At the probable cause conference, your lawyer will discuss this case with the prosecutor. That will take place September the 9th at 8:45, preliminary exam, September the 16th at 10:30. Those will be in front of me. And I want you to understand, if you're convicted of a 5-year felony, which RNC motor vehicle is, since you have allegedly the 3 prior felony convictions, you could get life. Do you understand that?
Yes.
All right. So September 9th, 8:45, September 16th, 10:30. You can go ahead and address bond.
Thank you, Your Honor. With regard to those priors, Mr. Tyson tells me that he served 10 years on the 2011 matter, and then successfully completed parole. And he's currently on probation to Oakland County on the 2022 matter. He said he was set to be released from probation September 22nd, so it's coming up shortly. He indicated he's had some health issues. He had a major surgery in December, has been unable to work since then. He is requesting court-appointed attorney going forward. And with regard to the bond, he indicates he really has very little money, and anything over 2,010%, he probably is going to be in custody until the next court date.
Lieutenant, what do you have to say? Does he have any holds, any other convictions?
Your Honor, he's got a few traffic warrants. Other than that, just what we already stated in court, but I'll use the court's discretion.
You said he's got some traffic warrants?
I believe so, Your Honor.
I'm sorry?
Yes, Your Honor, he's got 3.5 pages of them.
Yeah, you got 8 warrants, 9 warrants. You cannot leave the state without the consent of the court or violate any law or ordinance. You must appear in court as directed. No contact with Robert Ida or Todd Taylor. No contact with either one of those individuals. Also, no contact with prosecution witnesses. 20,000, 10%. You got to show up in court, sir. You can't have multiple warrants and expect a personal bond. 20,000, 10%. You're going to have to post $2,000 to secure your release. September 9th, you'll be back in front of me. Any questions? Any questions?
Yeah. You said 20,000?
20,000, 10%. Yes, sir. You got to show up in court.
I show up. I always show up.
You got 8 warrants. No, you don't. You got 8 warrants. Come on. Don't argue with me.
Okay.
You got 8, I think 9 warrants, actually. Good luck to you. You got to show up. Thank you.
Thank you, Judge.
Thank you.
Thank you, Your Honor.
Thank you. Haley Krieger. Haley Jean Krieger, 23B144245. Good morning.
Good morning.
Your name?
Haley Krieger.
So you're charged with failure to refrain from consuming alcohol, testing positive on August 25th. You admittedly drank. This says you have prior technical violations. Your probation could be revoked and you could be incarcerated for the maximum provided by law, which is up to 93 days. Do you understand that?
Yes.
You're presumed innocent. They have to prove you guilty by a preponderance of the evidence. You have the right to question their witnesses, to bring in your own, to use the subpoena powers to court, to bring in those witnesses. If you plead guilty, you'll be giving up all those rights and there will not be a hearing. Do you understand that?
Yes.
All right, you have the right to an attorney. I'll be happy to give you one at public expense. Would you like a lawyer?
No, thank you.
You waive your right to a lawyer?
Yes.
Call in Emily. To the charge that you failed to refrain from consuming alcohol, testing positive at a chemical test on August 25th, how do you plead?
Guilty.
Did you drink alcohol, say, within the 3 days preceding this?
No.
No, listen to my question.
Sorry.
Did you consume alcohol within the 3 days before August the 25th? What did you drink?
I had a Bloody Mary.
Where?
I was at brunch with a friend.
At where?
Public House. It's a restaurant. I
What
was
date?
at brunch with a friend.
Anybody force you to plead guilty?
No.
All right. All right, I'm gonna accept your plea. I'm gonna get Emily in here. Haley, what are you doing? Come on, talk. You're ready to graduate, right?
Yeah. It's not a relapse or anything. I'm still on my track. I just messed up.
Your name?
I'm like, yeah.
Can I please see the letter you were referencing? Haley, why?
I know. It was careless on my part.
So this is the third or second time she's drank?
Would be the second. I believe her last one was 4th of July, 2024.
Where'd you go?
This
Yeah.
one, I was at a restaurant. It's called Public House.
Where's that at?
In the room.
I placed her on probation, I believe, on November 29th of 23.
So she, if we kept her to the end, she would have, what, 94 days?
What do you think?
You know, I do give her a lot of credit for being honest, you know. I don't know, she didn't send it to the lab, but if it was one, you know, she could have got away with it potentially. You know, she was honest the last time too, you know, I genuinely think she's trying. You know, she is probably someone that, it's not ideal, but that I would advocate to keep to the end. I would like to probably get her back into treatment. She has already completed, and, you know.
Relapse prevention, right?
You went to guidance center, right? Yeah, they would, they do have the relapse prevention group. And she is phase 4, so she's once a week testing, so, you know, probably some, at least yellow for the time being.
Oh, boy. Haley, I've been so proud of you.
I know. I'm disappointed in myself as well.
What's, so you want her to test twice per week, right?
Correct.
So when am I gonna, graduate her though?
What, I don't even know what day that falls on.
29th is a Monday. The 25th is probably Thanksgiving.
Well, we're off Thursday, Friday, for Thanksgiving status review, it'd probably be that Tuesday or Wednesday, I would imagine. So it would still be 90, we have 4 kind of days, she would still graduate with 90, even if it was that Tuesday, right?
Anything else you want to say before I sentence you?
It won't happen again, and I really apologize.
Pay costs in this case in the amount of $75. Serve 2 days on the court work program and pay $70 for those days. You're to attend a relapse prevention program. You're to test twice per week until the end of probation. You owe $145. I'm going to give you until, I don't know when you can pay it. I'm just going to say September the 12th for you to pay those costs. I'll let you guys worry about what day we're going to do it. I don't know what day we can do it.
I'll figure it out.
First is,
I haven't figured out your dates that far.
I got it. Haley. No more. Come on. Too close now, and we're not gonna be able to, you're not gonna have us looking over your shoulder. I know, but I'm talking about when you're done with the program. You're right here. You've done fantastic. I mean, you go back to that life and.
I don't want to, I've changed a lot.
I know you have. You're a great kid. I think the world of you. No more. Come on. All right? Good luck. Thanks.
Thank you.
People against Amanda Justine Garrett, 25T700567.
Deanne Patillo on behalf of Ms. Garrett. State your full name for the court.
Amanda Justine Garrett.
Ms. Patillo, I just want to make sure you know what's going on here.
Somewhat, Judge.
So I sentenced her initially.
Yeah.
And that was back in May sometime, May the 20. And then she came up with this probation violation and she went inpatient to her credit on her own in California. And at that point, I sensed that she needed some help and I said, why don't we convert this to a sobriety court case? She seemed amenable. That's where we are with this now. So I'm going to go ahead and put her in sobriety court. And I'm going to take into account, if you saw this one place here, let me just find it.
Are you talking about?
She paid all the fines except she still owes. She's still going to have to pay the $400 in probation fees. I'm sorry. Wait a minute. Let me just double check one thing. This is where it's going to get kind of complicated. I just want to make sure. So initially I placed her on probation on May the 20th for 12 months. So I need to add some more probation fees because we're going to make it 20 months, which will essentially make it 24 months. Okay?
$400?
It's a lot more than $400.
How do I choose it for another, I mean, I'm getting more probation. I know that, but like, so I have to pay to be in this program?
Oh, yeah. Now, listen, we're not a money-making outfit, but we have to. There's nothing I can do on
I mean,
that.
I paid, I think, what, 2,000 some dollars, or 3,000
Let me double check.
on May something?
Hang on one second. I initially ordered 1205.
Maybe that's what it was.
It's a far cry from 3,000.
Okay, but I haven't, it's been a while, but so I need another 400 or 500.
I'm gonna give you time over to pay this.
Okay,
I'm not looking.
I'm a stay-at-home mom, so. Looking to get back in school.
All right. Did you review this report with your client? And are there any material additions, corrections, or deletions?
Yeah, we did review the report. There are no additions, deletions, or corrections. The updates that she gave me are already in here. She's gonna be transitioning from the new Oakland into the Guidance Center. And she has her orientation on September 5th, 2025.
I spent over $600 at New Oakland Family Center just to come to realize that it doesn't count toward my probation. So I've almost completed that program and dropped a whole lot of money that I didn't have to.
Wait till the probation officer comes in that's been working with you. What else?
Other than that, Judge, there's no additions, deletions, or corrections. She did indicate to me, we went through that list of recommendations from probation. And Ms. Garrett just stated that she's already doing a lot of that. She also
She
brought
is,
her-
but she's paying for her testing right now. We're gonna start to pay for it. She's gonna pay for,
But then I gotta pay 400, so, right?
Okay. Do you wanna see my list of meetings?
no,
Okay.
that's why we have Ms. Tessino and other probation officers here.
2
Your-
years of me.
Your name?
Emily Tessino.
All right. So she's kind of questioning the fees, and that's understandable. It's a lot of money. Nobody's gonna debate that with you. I wanna sentence her, but I want to make sure that I'm not missing anything. This one's a little unique because she was already in regular probation. Have I let you finish?
Yep. Unique is the right word for it.
At least you're bubbly. I need bubbly. Huh? I don't need people getting angry and yelling.
No, dude.
All right, we're gonna help you.
Okay, that's what I'm hearing.
You know, seriously, you know how good this made this field? We had somebody graduate yesterday. She did a great job. She was a mess, to be honest with you. I'm not gonna mention her name, and then she graduates, and you can just see what a difference in 2 years she's become. And you're gonna see those stories all over, and I hope you're one of them.
Uh-huh.
20 months probation going forward from this point. You cannot leave the state without the consent of the court. You cannot violate a law. You have to comply with all agreements, guidelines, and requirements as indicated in the Sobriety Court Handbook. You're to notify your probation officer of any change of address. You have to report as often as directed. No alcohol, no marijuana, no illegal controlled substances. You're not to purchase, possess, or consume any one of those. You're to submit the chemical testing on demand of probation. They're going to explain it. But from now on, you're going on our dime. We have grants to cover this. Submit the PBTs, ETGs, and chemical testing on demand of probation. I want you to complete 60 days on the Sober Link starting today on our dime again. Attend 12-step meetings 3 times a week and provide written proof of attendance. Obtain an AANA sponsor. Attend all substance abuse treatment at an approved facility. Attend the Victims Impact Panel. Attend and complete the Armed Specialty Court Weekend Program. Report to Sobriety Court status review hearings with me every 2 weeks. Obtain and maintain employment. You have to provide proof of that to probation. I've already ordered. You haven't done 3 days on the court work program, but you did pay for those, right?
Correct.
So I'm not going to charge you for those. I'll just make a note, already paid CWP fees. You do have to pay not $480 in probation fees because you already paid $240. So I'm going to order you to pay $240 in probation fees. I'm going to order that you go, I'll stick with, well, it's $15 a month times 20, so it's $300 in sobriety court fees, so you're up to $540. You already paid your victim's rights fee. You already paid your justice assessment fee. You already paid your screening fee. So that should leave nothing left to pay other than $540. I want to double check that with you though. If you violate, your probation could be revoked and you could be incarcerated in this case for a period of 93 days with credit for 1 day served. Now, I want to make sure, and you have 21 days to appeal and 14 days to apply for a court-appointed lawyer for purposes of appeal. I want to make sure she was given proper credit for everything. I think she was.
You mean in terms of the money?
Yeah. I think she only has to pay $540.
Yeah, because their original term was, let's see, was 12 months, I believe. So yeah, it'd be 12 more months of supervision.
So I'll let you pay those at the rate of $65 per month, and I'll start this beginning October 1. And you do that, and you'll have this paid in about 8 months. Can you do that?
Mm-hmm.
Yes?
Yeah.
I look forward to this, Ms. Garrett. I hope we can help you.
I hope so too. I look forward to the extra treatment.
Good. You have 21 days to appeal. You have 14 days to apply for a court-appointed lawyer. Did I cover everything?
I felt weird, I haven't had a probation one in a while, so I felt the same way you did.
Have a great day.
Thank you.
Good luck. Thanks.
Thank you.
Thank you. Jay Nolan. Jay Wall Orion Nolan, 25B148261. Mr. Nolan, your name?
Jake Will.
How old are you, Mr. Nolan?
22.
Okay. You staying out of trouble?
Yes, I counsel.
Counsel, does he stay in mute, wait formal reading?
He does, Judge.
And then
I have it to you on behalf of Mr. Nolan.
And then he's gonna plead to suspend, right?
Yes, Judge.
Is that what you wanna do?
Yes, sir.
If you do that, the possible penalties are up to 500 fines, 93 days jail, costs are all those 2 points. Do you understand that?
Yes, sir.
Did you sign, read, and understand it, advice of rights?
Yes, sir.
If you plead guilty, you'll be giving up all those rights. There will not be a hearing or a trial. Do you understand that?
Yes, sir.
To the charge driving on a suspended, how do you plead? Were you operating a motor vehicle on Gibraltar near Allen and Woodhaven and Brownstown, May 31 of 25?
Yes.
Was your license suspended, revoked, or denied?
Suspended.
Are you on probation or parole?
Yes.
For what?
CCW.
Anybody force you to plead guilty?
No.
By pleading guilty here, I want you to understand this would be deemed a violation of that probation or parole. That probation or parole could be revoked. You could be in prison on that charge as a result of this plea and conviction. Do you understand that?
Yes.
Anybody force you to plead guilty?
No.
Please accept it. I've never, you know how many warrants you got?
Probably trying to take care of it.
You're not trying to take care of
I
it.
just got out of jail on Friday.
I hope you have some money to pay, because I am not giving you a payment plan and letting you walk out when you have somewhere in the neighborhood. I don't even know if I can count this high. He's got to have 40 warrants on here.
Your Honor, so I guess there was a ticket he had before Judge Heston. I guess he got time served on that ticket. I don't know if you're.
Good for her. That's nice of her. But time served.
I'm not sure of the facts of that situation, Your Honor.
Judge, he had multiple cases. He just saw her recently while he was in custody.
I get it.
Your Honor, I would say he's gonna be monitored, right? I mean, I know the court may not want to go if he can't pay anything today, but he's on felony probation, so he's definitely.
Well, I didn't say anything about placing him on probation. I can't look at a guy with 40 warrants and think that he's coming back here to pay.
He will.
Oh, I'm sure. He's thumbed his nose at all these other judges and somehow I'm so special.
I tried to.
He'll come back.
I tried to take care of all of them while I was incarcerated, but they denied all of my other people.
Who did?
36 district.
That's where the majority of them tickets come from.
Do you want me to really?
Probably want him to come.
You want me to really go through these? 1, 2, 3, 4, 5, 6, 7, 8. Everybody acts like it's okay to abscond on the 36th. You know that? Everybody acts like it's okay to abscond on the 36th district court. Like there's some, well, that's okay. It's just 36. I don't get it. Detroit, you live in Detroit. That's close to you in Detroit. Right?
Yes, sir.
Well, why didn't you go over there? Of course they're not going to be nice. Look at this. You got 13 warrants other than Detroit.
Judge, he spent 90 days in jail. I know it was for an unrelated matter, but I would ask if the court can take that into consideration. I believe he'll come back and pay, Your Honor.
Where do you work?
I just was recently incarcerated, so I'm trying to find a job.
Where were you working before you were incarcerated?
I wasn't working.
Why? How old are you? You're 22?
Yes, sir.
You made up your decision to retire at 22. I love it.
I was
Well, why weren't you working?
trying to find a new job.
When did you last work anywhere and where were you working and how much did you get paid?
Last time I had a job, I was working at MJR.
And how many years ago was that?
I had like 2, 3.
Longer than that, wasn't it?
About 35 years ago.
What have you been doing? No wonder you're getting in so much trouble. How can you eat if you don't work? Somebody's got to let me in on these secrets. How do you get to eat if you don't work? How do you put a roof over your head if you don't work? How do you put gas in a car if you don't work? How do you pay for a car? How do you pay for clothes? How do you do anything?
Entrepreneur.
Entrepreneur. And what kind of an entrepreneur are you? Tell me, what kind of an entrepreneur are you? Now listen, are we gonna just kid one another, or you wanna just have a conversation here? It's time to grow up, entrepreneur. What are you talking about? What kind of an entrepreneur are you?
Man, I know how to work on cars and stuff like that too, so that's what I've been doing. If they don't believe me, that's just on you.
Are you licensed? What'd he say? What'd you just say?
I said, if you don't believe me, then that's just on you.
That's on me? Is that what you said?
Yeah, if you don't believe it. Not trying to be rude. Not really too much I can do.
Well, you didn't tell me anything about working on cars. You said the last time you worked was at MJR. Did I misunderstand you? And that was 3 or 4 years ago. And then I asked you how you eat, and you said you work on cars. How much did you make working on cars, say, in the 1 year before you went into prison?
Like 4 years?
Yeah.
I wanted to say,
More than 5,000?
yes.
Do you have your own garage?
I got my own set of tools.
Are you a licensed mechanic?
I went to Votek career training facility in high school.
Are you a licensed mechanic?
No, sir.
Your Honor, again, he did just spend 90 days in jail.
I get it. I'm just trying to make him understand. That's all. I'm not trying to be a tough guy here. I just don't understand. You got to rethink your direction in your life. You really do. Who's this with you? Pretty girl. You know what happens? I got to tell you a secret. Pretty girls don't want to hang out with guys that don't have money and don't work and get themselves in trouble all the time. So you might want to give that some food for thought. I'm going to let you go. I don't see any reason to belabor this. I don't think you're going to listen to one thing I said, and I think you're going to go on and continue to act like you have. I hope I'm wrong. It's one of those situations I want to be wrong in. But you cannot go through life, and I don't understand this kind of thing. I see it every day. I just don't understand how you'll feel like 5,000% better about yourself if you're working and earning a paycheck. Do you know what I mean? You really will. I mean, I don't know what you do all day. I don't want to know. I don't need to know. But what do you do all day when you're not working? I don't understand it. I'm simply going to, that's all right. You got other fish to fry here. And you did right. I see you wrote a plea by mail. I tried to put you in front of the camera. So I want you to understand, this is the beauty of the system. Listen to me. Listen to me. Just listen a second. We tried to get you in front of the camera. Defendant not put in front of camera, I wrote down July 3rd.
That was the jail.
I know. It was the jail's fault. And I probably would have given you credit for time served then. And because you showed up today doesn't mean, and because this county didn't put you in front of the camera isn't your fault. I'm not going to penalize you for that. I have plenty of reasons to be a tough guy and give you time to go to jail here and sit there for 60 or 70 days. Because you don't respect the system. You really don't. You're not going to. I'm not going to be a tough guy. I might talk a little tough. Because sometimes, some way, I want to get letters like I got and saying, Judge, you turned my life around like I got a couple of weeks ago from people that were in front of me 15 years ago. Maybe, just maybe, you're going to be one of those long after I'm gone from here. Write me a letter, sending it to the court saying, give this to McNally. He at least said some things to me that made me think twice, and I at least went out and made a living. I'm just telling you. This thing called life goes awful quick. You're hanging out on the streets. You're up to no good. You're not working. You're up to no good. You know what I know. Just that simple. But I'm not going to sit here and chastise you anymore. 100 fines, 200 costs, 75 victims' rights, $50 justice assessment, 4 1/4 or 30 days, credit 30, case closed. I hope you think about what I'm saying, though. You'll feel so much better about yourself if you're working. We have this thing called self-esteem, and all of us need to boost it for ourselves. Good luck to you. I really wish you well. I'm not trying to give you a hard time. I just hope you'll think. You seem like a nice kid who just doesn't respect authority. I'd encourage you to work on that one, too. Good luck. Jonathan Patrick Johnson, 25B148931. A and B, and I also have 148932.
Dion Padilla on behalf of Mr. Johnson. Mr. Johnson, state your full name for the court.
Jonathan Johnson.
All right, I gave him permission to appear by Zoom, did I, Lisa?
Yes, he doesn't have transportation, he can't drive.
Okay, so you're gonna plead guilty, he's gonna plead guilty to operating while intoxicated. He's going to plead guilty to open intox. I also have 931C, which somehow got stuck. That's resist and obstruct. They're dismissing the resist and obstruct. They're dismissing a PBT refusal. He's going to plead to OWI and operating while intoxicated, correct?
Correct.
Is that what you want to do, Mr. Johnson?
Yes, sir. Yes, Judge.
Possible penalties are up to 500 fines, 93 days jail, costs are all those 2 points on the OWI. I'm sorry, 6 points, license suspension or revocation in accordance with your record. Your vehicle could be or might have to be immobilized depending upon your record. Do you understand that?
Yes, Your Honor.
I got to have you keep your voice up nice and loud.
Yes, Your Honor.
If you plead to open intox, possible penalties are up to 100 fines, 90 days jail, costs are all those in 2 points. Do you understand that?
Yes, Your Honor.
And you are presumed innocent. They have to prove you guilty beyond a reasonable doubt. You have the right to a trial by court or jury. You have the right to question their witnesses, to bring in your own, to use the subpoena powers of the court to bring in those witnesses. If you plead guilty, you'll be giving up all those rights, and there will not be a trial. Do you understand that?
Yes, Your Honor.
Now, you had a prior drunk driving out of Ohio, true?
Yes.
Are you on probation for that?
No, sir.
Are you on?
No, sir.
Sir, are you on probation or parole?
No, sir. Neither one.
Anybody force you to plead guilty to this charge?
No, sir. No, Your Honor.
To the charge operating while intoxicated, how do you plead?
I plead guilty.
To the charge open intoxicants, how do you plead? Open intoxicants, how do you plead, sir?
I was trying to plead to that.
I just need to know how you plead. If you don't want to do this deal, you don't have to.
I didn't know that bottle was in the car. I don't know how to. I just never knew it was there.
On the car.
I do, Your Honor.
At some point you knew it was in there, right?
No, sir. I had family I was dropping off. There was people in the back seat, and we were just going home.
What do you want me to do here? He's got to have knowledge.
I told him he can set it for trial.
You want to set it for trial? Is that what you want? I mean, look, I don't want you to plead guilty to something that you didn't do. If you didn't know the open intox were in the car, I don't know how you couldn't have known that, then you shouldn't plead to it. But that's okay. If you didn't know, you didn't know.
I didn't, so I don't plead to it because I never knew it was back there until the officers. It was in the back seat. I'm driving after I dropped them off.
Hang on. I'll end the prosecutor. Let me go on the OWI case. Were you operating a motor vehicle on Telegraph near Emmels in Brownstown, June 27 to 25 at 11:50 p.m.?
Yes.
Did you drink alcohol prior to operating that vehicle? And if so, what did you drink and how much?
We were in that complex there where
I just want to know how much you drank and what kind of.
I think I had like 3 shots of Tito's.
Was your ability to operate the motor vehicle significantly and materially affected due to the consumption of the alcohol? And if so, in what way?
No, sir.
Well, you were pulled over, and do you know why you were pulled over?
Well, I was kind of coming out of the complex, so I was going left, but there was a car in front of me across in the parking lot. Not knowing what it was, I was allowing them to go, but they didn't go, so I kind of like gassed it a little bit to get out and beat traffic because I didn't know, I couldn't see if they were trying to come out or not, but the whole time they were officers. So when they felt the need to pull me over because I guess, you know, by me pressing the gas a little bit, they pulled me over. And so I put my blinker on and I slowed down. I wasn't even going over 30 and I was trying to find the shoulder.
My question.
Mm-hmm.
Did you feel a little bit intoxicated?
I wasn't
We can set it for trial. I've explained, I'm not even comfortable with a plea if he wants to set this for trial.
If you want to set it for trial, we can do that, sir.
Yes,
I don't want you to feel pressured to do anything here. It's the United States.
I have no transport. I have no way out there. Even if I did set one, so I was just trying to see what I can work out.
Counsel, were the breathalyzer, or was it a blood test or breath result? Your name?
Blood test.
Caitlin pulled a current request for time, but it was blood, it was a 0.133, Your Honor.
All right. You stipulate that that was an accurate reading?
Yes, I saw the report I have the police report, I have the test. And it's 0.13, it was a 0.133.
All right. I mean, I'm satisfied. That's UBAC. That's still operating while intoxicated. If you are, I'm not satisfied on the open intox. Hang on, Mr. Johnson. Mr. Johnson, would you just let me work on this for a second?
Yes,
you want to do something else and dismiss the open intox and maybe even plead the PBT refusal or something else or impeding traffic? I could care less.
I guess we can talk about it.
You want to talk about it right now?
I mean, I would be willing to give him resistant hinder, Your Honor, but it's my understanding that he doesn't believe he did that either, so.
Mr. Johnson, do you think you did anything wrong?
I was going home. I was just dropping my family off when we were coming from another, a little gathering. I was dropping them off. I did take a couple sips when we were in the trailer or whatever or whatnot, but I'm not aware of what was left in my back seats. I don't even know the amount. I don't even know anything. All I knew is I was just coming out and I was going home.
I'm going to hand these files back to your lawyer. I'm not taking any plea. She's going to go and talk to the prosecutor, and they're going to see if they can work something else out. Okay?
Thank you, Judge.
Do you have Schaefer?
Your Honor.
Do you have Joshua Schaefer?
Your Honor.
Okay, Joshua Edward Schaefer. Just don't go anywhere, Mr. Johnson. We'll be right with you. Joshua Edward Schaefer, 25B149-261A and B. Your name, sir?
Joshua Schaefer.
All right, so you want an adjournment? We'll give you a brief adjournment, couple weeks. What do you have for me, Lisa? What?
I get paid bi-weekly.
So
I know I have some fines to pay to get my license.
all right, we'll give you 4 weeks. I can't go more than that, though. Give me 4 weeks, Lisa.
September 18th at 8:45.
Is that gonna help you?
Yes, sir.
That's a little more than 3 weeks. Is that gonna be enough time?
Yeah, I appreciate it. Yes, sir.
Or do you need me to go a couple more weeks? I can do that.
Honestly, it's quite a few thousand in fines.
You're not gonna be able to pay them anyway, are you?
Not all of them right away, but I'm
Lisa, give me.
Judge, yeah, we can do the 24th also, September 24th at 8:30.
We'll do September 24th at 8:30. We'll see how you're doing. How's that?
Absolutely. Thank you so much.
All right, go down the hall. September 24th at 8:30, and they'll give you a notice, okay?
Yes, sir.
All right, best of luck.
Thank you so much.
You're welcome. All right, what else do we have here? What do I have? What do you have? What's his name?
His name is Jude Dad. He was supposed to be here yesterday.
You wanted the defense attorney?
Situation.
Do we have a daily file down there, Lisa? Did you check it down the hall?
Yes, sir. Begley, B-E-G-L-E-Y.
Begley. So we'll pull your file. Man in the back, I'm sorry, what do you have?
Joseph Hoffman, he sent us out, but he's after trying to put everybody before us.
Huh. We'll check into what's going on out there.
Begley's a walk-in, so may not have file.
Thank you.
Did they bring Demps back in yet?
Yeah, I just got.
She just did, yeah.
Okay.
Apologize, I literally.
What do I need Demps in here for?
He has weapons, so they wanted to talk to you about that.
DeKale, Quatez, where's Mr. Haynes? I need Mr. Haynes in here on this. Mr. Haynes was the lawyer representing him. DeKale, Quatez, Demps, 25B706-301.
Yes.
Give me 1 second, I'm gonna get your lawyer in here.
Can you zoom in real quick with that back? Yes. He'll be in.
Detective, your name.
Good morning again, Your Honor. Detective Crystal Tulas, Brownstown Police Department.
I don't know if he's zooming or what he's doing. Yeah, I need Mr. Haynes.
Zoom, Judge.
Mr. Haynes, your name?
Sherwood Haynes, we have Mr. Demps.
I don't know what's going on. So I was told there's something about a weapon. What's going on this?
Your Honor, it was my understanding that you said that he was not to possess any firearms or dangerous weapons, but there was no designation by the court on what you wanted Mr. Demps to do with the firearms that he already possesses.
Surrender them to the police. You're to surrender your weapons to the police. Do you understand that, sir? To the Brownstown Police Department. Do you understand that?
Yes.
Have you posted your bond?
No, not yet. No, we're still waiting on the paperwork.
Surrender to police by the end of the day. So you got some moving around to do. You got to go out to Warren. You got to go to Brownstown. Get somebody to bring them if they're legally. Where are they? At your house?
Yeah, they're at home. Yes.
And you live in what city? Detroit? I thought
I
I
live
saw
in
Brownstown. Okay, well, you're nice and close. You can go over there and get those after you post your bond, bring them over to the police department, and then go to Warren. How's that?
That's fine.
All right. Anything else, Detective?
No, Your Honor, my apologies for this. Thank you.
That's okay. Have a good day. Thank you.
You too, thank you.
People against Johnson. Jonathan Patrick Johnson, 25B148931, A, B, C, and then I also have 24B 148932. Mr. Johnson, your name?
No, I put him in a breakout room. Let me move him.
So we're going to need a jury trial and a final pretrial date.
He's not moving. I got to close all the rooms.
Okay. Everybody good?
Yes.
Glad to hear that. Yes. All right, Mr. Johnson. Your name?
Jonathan Johnson.
All right, I'm gonna set a jury trial and the final pretrial date. I just want to be clear, you're gonna have to figure out a way to get here for your jury trial date. Give me a jury trial date in about a month or so, Lisa. This is a July, well, I just arraigned him August 13th, didn't I? So we can set let's just set another pretrial date in 2 weeks, and I'll worry about setting the jury then. How about that? September what?
September 10th at 9:45.
At 9:45. Defendant can appear by Zoom, okay? I'll let you do that, Mr. Johnson.
Thank you so much.
September 10th at 9:45. Are you working, sir?
Yes, sir, I am. And I pay child support.
How are you?
He works from home.
Okay, I pay child support. I love when people tell me that.
It's a whole nine.
I mean, we all pay child support if we have killed children, you know what I mean? That's just the way it is, whether you're divorced or not. All right, we'll see you here September 10th. I wish you well. Good luck.
Calling case number 25, RO 04760. This is people of the City of Royal Oak versus Evan James Sissel. That's you, sir? Can you unmute yourself?
Yes, what was the name again?
Oh, I apologize. Wait a minute. You are the wrong party. You are Cameron Johnson.
Yes.
All right, stand by.
Okay.
This is case number 25 RO 05102. People versus Cameron Durrell Johnson. That's you, right?
Correct, yes.
All right. Thank you. Mr. Johnson, you were present earlier today when the court explained the nature of an informal hearing. Is that true?
Yes.
So you understood the court to instruct that you must select one of three options to protect your own rights, correct?
Correct.
Thank you. Mr. Johnson, the citation before the court was issued on August 8th. This year at 2:11 in the evening, you were operating a 2007 Ford Mustang black in color on Woodward Avenue at or near Coolidge Highway, City of Royal Oak. And at that place and time, you disobeyed a traffic control device. Officer Gertler's remark, which appears on your ticket in the middle there, says, exited 30955 Woodward and disregarded do not enter posted sign at crossover proceeding into crossover. So the citation is disobeyed traffic control device. You may, at your option, Mr. Johnson, admit responsibility in this matter. You may admit and explain, or you can deny responsibility. We will swear the parties and take testimony. What would you like the court to do for you?
I would admit and explain.
I'm sorry?
I said I would admit and explain.
Very well. So you're confirming to the court that on the date in question, you were operating a motor vehicle in the City of Royal Oak, and at that place and time, you disobeyed a traffic control device, correct?
Correct.
Thank you. The court is grateful for your honesty. Mr. Johnson, what do you want to tell this court?
So as I was exiting, like the exit, the goal was to go across the street into the parking lot across. I forgot which store it was, but as I was exiting, there was a car ahead of me that shot straight across, and also because like my car is low, there was headlights coming from my left side, and I didn't really see or pay attention to the do not enter sign.
Okay. All right. Thank you for your information. Officer Gertler, what would you wish to share?
Yes, Your Honor, I would like to make a motion to amend this to impeding traffic, please.
All right. Mr. Johnson, impeding traffic is a beneficial motion. That's a 0-point violation, will never appear on your master driving record. That's acceptable to you?
Can you say that again, please?
Impeding traffic is a 0-point violation, will never appear on your master driving record. Is that an acceptable outcome for you?
Yes.
All right. So your original plea to disobey will subsume a plea to impeding. The fine is $175. That is payable through the pay portal on the 44th District Court website, or you may walk a cash check or charge into this court, 400 East 11 Mile Road, Monday through Friday between 8:30 and 4:30. That's going to be due within 14 days. Be careful out there. Good luck. Take care.
Okay, thank you.
Court calls case number 25, RO 04760. This is people of the City of Royal Oak versus Evan James Sissel. Mr. Sissel,
Yes.
good morning.
Morning.
I believe you were present earlier when the court explained the informal hearing process. Yes or no?
Oh, no, I was not.
Very well. Mr. Sissel, this is an informal hearing. It is non-criminal in nature. Nobody's going to jail this morning on this ticket, but it is considered serious enough that Officer Gertler did issue the citation on the date in question. That date was July 21 this year at 4 minutes of 8 in the evening. You were operating a 2008 Suzuki GSX R600. So that appears to be a two-wheeler on 12 Mile Road at or near Vermont in the city of Royal Oak. And at that time, you were cited for speeding minimum of 1 to maximum of 5 miles over. The officer's remark, which appears on your ticket, indicates speeds anywhere from 42 to 50. This is over by Vermont. So this is over by Red Run, right, Officer Gertler?
Yes, that's correct. Traveling westbound alongside Red Run.
Very well. So, Mr. Sissel, you have 3 options to protect your rights. You may, if you wish, admit responsibility to this matter. The court attaches the fine that closes up your case. Or you can admit responsibility with an explanation that you believe mitigates your circumstances. Or your third option, deny responsibility. The court will swear the parties under oath. We will conduct a brief trial. The officer will testify first. He has the burden of proof. Then it's your turn to tell the court whatever you wish the court to know about the incident. And then the court is required to make a finding of responsible or not responsible based upon the civil burden of proof, which is a relatively modest burden of a preponderance of the evidence known as the featherweight test. So, as to speeding 1 to 5 over, do you wish to admit and explain, or deny responsibility?
Do I have an opportunity to speak to the prosecutor?
There is no prosecutor. This is an informal hearing.
Okay. Well, I would like to, was wondering if there would be a chance to call for a walk for an impeding traffic. I have some
Mr. Sissel, the court's not in a position, because this is an informal hearing. There are some fairly strict rules that the magistrate has to abide. There are 2 parties before this court. You have, obviously, your 3 options that the court explained to you. The officer brought the case. The city of Royal Oak is one of 2 cities that are within this court's jurisdiction. The court's not in a position and doesn't have any authority to haggle to tell you what the possible outcome is going to be. The court can only offer you your 3 options. So you may admit responsibility, you can admit and explain, or you may deny responsibility and will swear the parties and take testimony. What do you wish the court to do?
deny responsibility.
Very well. Would the parties please raise their right hands? Do you both solemnly swear the testimony you shall give before this court shall be the truth, so help you God?
I do.
Yes.
Thank you very much. The officer proceeds, and then it's your turn, Mr. Sissel. Officer Gertler.
Yes, Your Honor. On the listed date and time, I was operating in a marked patrol unit. It is a K9 Tahoe, operating as a uniformed police officer in the city of Royal Oak. I was traveling westbound 12 mile, which the posted speed limit there is 35 miles an hour. I was in the left lane as we approached Vermont. I was traveling at 42 miles an hour, give or take, when the defendant here operating the motorcycle passed me in the right lane and continued at a speed greater than what I was doing in my marked patrol vehicle on a certified speedometer. I immediately activated my emergency lights, given that in most cases, motorcycles tend to have an abrupt notification to flee. Upon activating my emergency equipment, the motorcycle showed no indication of pulling over. I had then activated my siren, at what point we were able to get him stopped. And then we had our conversation. And due to the fact that there was no official speed reading, however, my certified speedometer was traveling at 42 miles an hour, he was given a citation for at least 1 to 5 miles an hour over.
And I believe you suggested you were in a K-9 unit that was fully marked, correct?
It's technically semi-marked, but yes, that's correct. It is a marked patrol vehicle.
All right. Anything else you wish the court to know, Officer Gertler?
The last thing that I do have on this is, if necessary, I would be able to share a screen and provide dash cam footage of the incident.
Is that queued up?
It is not. I would be able to, if that is necessary.
We can provide that on rebuttal. Mr. Sissel, your turn. What would you like the court to know?
Well, I'd just like the court to note that there was no objective, reading of a speedometer. There was no device that was as stated by the officer. There's nothing as objective proof to verify the actual speed I was going, just based off of his, accounts personally. And it may have been flawed. I mean, as we're humans, we're flawed, whereas computers and technology doesn't lie. So I want the court to please respectfully note that there was no objectable, proof of the speed I was going.
Okay. Is there anything else you want the court to know?
Not this time.
Thank you. Officer Gertler, rebuttal testimony.
I have nothing further except for I can cue the dash cam footage if that's necessary.
That would be fine.
Okay. If you can just give me one short moment here.
No worries. Please stand by, Mr. Sissel.
Is queued. I just have to share the screen real quick.
No worries at all.
Okay. So I've queued this dash cam video to include at the top left corner of the screen there, which I'll expand in a second here, my patrol vehicle's certified speedometer reading.
Very well.
This is me traveling westbound. This is entering the intersection at 12 and Campbell, continuing westbound on 12 Mile. And also up in the left-hand corner, you'll see a notification when my light bar is activated.
Okay.
That L indicates that my light bar has been activated.
Gotcha. And it appears as though, at least at this point, your speed is anywhere from the high 50s to the low 60s. Is that right?
That is correct. I believe that the top speed that I saw there was 55 miles an hour as I was trying to attempt to catch up and get the motorcycle stopped, which is why I estimated the actual speed of the individual to be at approximately 50 miles an hour in the 35.
Very well. Any further rebuttal testimony? Officer Gertler.
Oh, no, I have nothing further, Your Honor.
Okay. The court is ready to rule. First, Mr. Sissel, the court wishes to reiterate the fact that because we are not in criminal court, but actually in civil court, this is a civil infraction. The burden of proof required for the people to prevail would not be guilt beyond a reasonable doubt, quantified at 99%, but simply a preponderance of the evidence, which is quantified at 50.1%. The court also notes that civil infractions do not require a demonstration of intent. A civil infraction could be committed either through negligence or inadvertence or as an intentional act. And the last thing the court wishes to make clear is has no idea what your driving record looks like. The court doesn't review driving records prior to undertaking a docket. The court judges each and every case on its merits. And judging this particular matter in that fashion, the court finds ample evidence to the standard of a preponderance that you are responsible for the civil infraction. The good news being the margin of speed, if it were in fact written in that order, could have been considerably more consequential. The fine in this matter, Mr. Sissel, is $130. That is payable through the pay portal on the 44th District Court website, or you can walk a cash check or charge into this court at 400 East 11 Mile Road, Monday through Friday between 8:30 and 4:30. That's due within 7 days. If you wish to appeal the court's ruling, you may do so by posting a cash bond of $130 within 7. The matter will be placed upon the formal hearing docket of the chief judge, and the city at that time would be represented by a city prosecutor. So 1:30 is a bond or a fine within 7. That completes your hearing. Good luck to you, sir.
Appreciate it. Thank you so much, Your Honor.
All right, officer, I've got a couple of unmarked devices.
Hello.
Good morning. What is your name, please?
I'm Devia Harris.
Thank you. Stand by, please.
Okay.
All right, the court calls case number 25 RO 04585. This is people of the city of Royal Oak versus Devia Larzetta Harris. That's you?
Yes, that's me.
Ms. Harris, today's the date and time set for an informal hearing. An informal hearing is non-criminal in nature. Nobody goes to jail today on this traffic ticket, but it is serious enough that Officer Gertler did issue the citation on the date in question. Ms. Harris, the date in question.
I don't want to think it doesn't say which ticket it was. It just say the date I supposed to appear for court, but I know I had set a court date for a
Yes,
ticket
that's
that
what
they
the
just
court is
told me
trying to
to do.
explain to you. Today is the date for your informal hearing.
Oh no, I know that. I'm trying to see which ticket though, because I had set a date for 2 different court dates, but they said that I just had to bring the picture up and he would cancel the ticket. And then one was to get my tags, but I had already had my tags, but somebody stole my tags. And he said to replace it.
Ms. Harris, the
and to
court is
bring it.
required to first read the citation into the record. So if you would permit
Oh,
the court
okay.
to speak, thank you. On July 14th of this year at 9:15 in the evening, you were said to be operating a 2008 Ford, black in color, on Woodward Avenue and near Lincoln in the city of Royal Oak. And at that particular point in time, it was found that your vehicle plate had expired on your birthday last January. So the citation is a non-moving 0-point violation of expired plates. You have 3 options. You may admit responsibility in this matter. The court will attach the fine and that'll close the case. You may admit responsibility, but with an explanation that you believe mitigates your circumstances. If the registration has been renewed, it would be great to be able to see that. Or your third option is to deny responsibility, which would mean you're swearing under oath that the plate was valid in July, and we will swear the parties and conduct a trial. What do you wish the court to do for you?
I was instructed by the officer to do the second option. My plate, I have my tags, and he just said present a picture, and then he would throw it out. That's what the officer said. But I'm saying the second option. But
Ms. Harris, the court has no idea what the officer said or didn't say. What the court is required.
Dad, you can pull the video because he said he was going to be here today.
Ms. Harris,
the officer
please
told me he was
listen.
going to
The
be here.
officer is here. Stop
Okay.
talking over the court, and we can conduct the hearing as fairly as possible. Please, when the court is speaking, do not speak over the court. Otherwise, we have a very confusing record for any potential appeal purposes. So please listen carefully. You have 3 options and 3 options only. Before we talk about what an officer said or didn't say, whether somebody stole tags or not, before we get into any of that, the court has to take a plea. So please listen carefully. You can admit responsibility, or you may admit responsibility and explain, or if you believe you are not responsible, you have every right to deny responsibility and we'll conduct a brief trial. But before you explain anything, you must choose one of those options. Admit and explain, or deny responsibility. Please select.
Number 2 option, you just said if I renewed it, you would like to see it. Number 2.
I didn't say anything. I just said you need to make a
Yes, you
plea.
did.
So
You
you
gave me 1, 2, and 3.
Ms. Harris.
You're
Ms.
trying
Harris.
to hang up on me. Yes, you are. You're trying to be rude and hang up on me like I'm rude and I'm slow and I'm not. You said 1, 2, and 3, which my birthday is 1, 2, 3. So I understand. Yes, sir. 2.
Harris?
You gave me 3 options. I said 2, sir.
All right.
So the first time you explained 2.
Ms. Harris? I know it's difficult.
It's not difficult, sir. I said two. I don't want to go back and forth with you. You're grown. You're in charge.
You're not going to
You're
go
in
back and
control.
forth with this court, Ms.
I'm
Harris.
not. I'm
So,
not.
You
Two.
wish to confirm that on the date in question, you were operating a motor vehicle in the city of Royal Oak with an expired tag? Yes or no?
Yes, that happened, sir.
I'm sorry?
Yes, that happened, sir.
All right, thank you. The court accepts your plea. And what would you like the court to know, Ms. Harris?
I didn't say I put in a plea. I said that I admit.
Yes, that is a plea of responsible, Ms. Harris. What
Okay,
else would-
well, is the officer there? Because I have the tag, sir. I have never went through this much. It's a California call, which is a conspiracy related case. It's been 15 stops. I said number two, sir. I have my tag. It's
All
either
right,
you can.
that's fine, Ms. Harris. Can you display
Okay, I feel like you're being biased, sir. I would probably like to switch court to a different court date. I feel like you're being biased. Yes.
Ms. Harris?
Everything is on recording, sir. Yes, I feel like you're being biased. I would like to. I don't feel comfortable at all. I feel like you're being biased, and I would like to switch court dates because the officer did not tell me this or the
Today
other
is your
call
day
or
in
no
court.
other court
You
did
have
this.
already confirmed that you admitted responsibility. The court
Yes,
is simply
yes, but
asking.
you're biased, sir.
Ms.
You're talking
Harris.
to me like I'm slow or incompetent.
No, Ms. Harris, if anything, you're not slow. You're too fast because you're speaking over the court. So the court is
No,
not suggesting
yes,
that you're
because
slow
you're
in
talking to me
any
like I'm
regard.
illiterate.
Ms. Harris, we are conducting an informal hearing. Each and every word is being recorded. So
That's
the record
fine.
will speak for itself, but the court is asking
You
now.
said 1, 2, 3,
if
right? You gave me 3 options, and you
Ms.
said
Harris.
13 people were on the call, right?
Ms. Harris.
Okay. 13 is when I got raped, and they've been trolling it for
Harris.
2 years. It's on the
Harris.
record, right? 1, 2, 3 is my
You're on.
birthday. Thank you. Yeah.
Ms.
I
Harris,
got raped at 13, and they were trolling it for 2 years. You the
Ms.
third
Harris,
court
can you
trolled my
please
rape.
display,
Yeah.
Ms. Harris, can you please
It's on the record.
display, Ms. Harris, can you please
Yes.
display your license registration?
My license plate is outside on the car. This is not video. I'm on a telephone call. So do you want me to send it into an email
Thank you
just
very
like the
much.
court?
The court appreciates everything that you've suggested, Ms. Harris. Please stand by
I
before the
asked.
court imposes
I didn't
a
suggest
sanction.
anything, sir. I asked. I didn't suggest anything. I asked a question. My plate is outside.
The court can't see through your telephone, Ms. Harris. So at
Email.
this time, the court
Email,
is
sir.
assessing a
Email,
$45
sir. I have
minimum state
I have
fee
an email.
that is due
Okay, well,
within
I would like to put in a
7
motion.
days.
Okay, no, I would like to put in a motion because I have it renewed, and that's not what the officer told me. And last time, Roseville and every other court let me use email.
Ms.
I don't have
Harris,
to let you
the
in my
court does
phone
not
due to my
have an
phone being
email.
hacked.
Today was your day in
Oh.
court. Officer Gertler,
No, that's
have you by any
okay.
chance
Okay,
run
well,
this
I would like
plate?
to put in a motion, sir. I would like to put in a motion.
I don't have anything further.
I'm gonna pay the
Very well.
$45.
Ms. Harris, the fine is $45. That is
I'm gonna
payable.
pay the $45. I would like to put in a motion. The
Very
last
well.
time I was able to put in a motion. Yes, because that's what
You
you're doing.
The court does not
Yeah,
recognize your
I can
motion.
pay the
It is not
$45 with no
timely.
problem, sir. But you just trolled rape at
$45
13
within
years
7
old.
days, Ms.
Yes,
Harris.
and you
Good luck
trolled my
to you.
birthday. No, oh no, it's on record.
Thank you.